Okay, are we going live now?
We're live. Welcome to Navigating Criminal and Civil Legal Proceedings. This is Session 1, Stream 2 with Loretta Merritt. My name is Helena Kamika and I'm your moderator. If this is not the session you planned on attending right now, simply go to the Sessions tab in the menu on the left side of your screen and then click on the session that you're interested in attending. I'm pleased to introduce Loretta Merritt as the speaker for this session. I encourage you to read her bio in the speaker menu, as I can't possibly do her justice in the short time that I have. I will say, as one of the first lawyers in Ontario to represent sexual abuse survivors, Loretta has built a robust practice exclusively devoted to this work. Her deep understanding about the intricacies and complexities of these sensitive matters enables her to identify and communicate with abuse survivors while fervently championing their causes and skillfully meeting the most challenging legal disputes to gain a sense of justice and closure. Welcome, Loretta. We're so looking forward to your talk today.
Thanks so much, Helena, and good morning, everyone. So my topic for today is an overview of criminal and civil legal proceedings, specifically in the context of sexual assault and domestic violence matters. So for today, what I'd like to do is give you a brief overview of the difference between the criminal and civil justice systems and touch on the purpose of the different types of proceedings, who are the parties, what are the issues that can be addressed in each. As well, I'll speak to you about confidentiality and what's available in each system, time limits. I'll try to highlight some of the advantages and disadvantages of the criminal versus the civil justice system, and then get some practical information to you about how it will go and some tips. So starting with the criminal justice system, the primary purpose of the criminal justice system is punishment of the criminal. The parties are Her Majesty the Queen, or the people, the government, the state, against the accused person, the perpetrator of the assault. And that's an important point, because the abuse survivor, who is called a complainant in the criminal justice system, is not a party to the proceeding. That complainant does not have the right to be represented by a lawyer except in very, very limited circumstances. And it's really a case that is between and about the people against the accused. So there are two main issues in a criminal proceeding. The first is the accused person guilty or not guilty? Now, the accused person is always asked at the outset to plead either guilty or not guilty. If the person pleads guilty, then we simply skip over step one and go straight to step two, sentencing. If they plead not guilty, then a trial is held to determine guilt. The burden of proof is on the Crown Attorney, who is representing Her Majesty the Queen, and the burden is a high one. It's a burden to prove guilt beyond a reasonable doubt. The complainant's evidence obviously is a key component to the Crown's case and establishing that guilt beyond a reasonable doubt. But again, the burden is not on the complainant, the burden is on the Crown to prove the case. If the Crown does not prove the case beyond a reasonable doubt, the finding is not guilty. It's important to note, and particularly when trying to support survivors, that there is no finding of innocence. All right? A court will simply say guilty, not guilty at the end of a trial. They will not find that the abuse did not happen. Basically, what not guilty means is the Crown did not have enough evidence to meet its high burden, or there was some other technical reason why a finding of guilty was not made. If there is a finding of guilt, then, of course, the court moves on to sentencing. And at that stage, victim impact statements can be made, and often are made, with a view to helping the court to understand the effect the offenses have had on the victim, with a view to getting a higher sentence. obviously, the government is responsible for enforcing the sentence. They employ the probation officers, they run the jails, they are solely responsible for ensuring that the sentence is carried out. The abuse survivor has no role in that, except maybe when the accused person comes up for parole. Again, they may want to appear at a parole hearing and make submissions about why this person should not be granted parole. But basically, the entire burden of the case is borne by the government. In terms of confidentiality, the Crown can request a publication ban, and such requests are often made in historical abuse cases where the complainant was a child, or in sexual assault cases, and as well often made in domestic violence cases. The interesting thing is, where there's a minor or a sexual offense, if the Crown makes the request, the judge must grant the publication ban, which prevents anyone from identifying the complainant. These publication bans came into existence with the intention of protecting victims. That was sort of the idea behind it. But lately, there has been more and more discussion about how they may in fact backfire and silence survivors who wish to speak about their abuse. Because of course the publication bans apply to the survivor, and they cannot be revoked by anyone except the Crown Attorney can ask the judge to revoke it, even after the survivor dies. So there has been of late more and more discussion about the fact that Crown Attorneys should be consulting with complainants before requesting a publication ban. And obviously it's a matter of extreme personal importance to the survivor. So there has also been discussion recently about the fact that the law ought to be changed so that publication bans never apply to the complainant. And I think, of course, that makes a lot of sense, but we're not quite there yet. My suggestion on a practical basis is, if you are involved in a criminal case or counseling with someone who's involved in a criminal case, is to have a discussion with the Crown about the idea of a publication ban, even if the Crown doesn't raise it. Because again, it can silence the victim for all eternity. And that may or may not be something that the survivor wants. In terms of time limits, there is no statute of limitations for crimes. You know, a criminal charge can be laid even decades after a crime was committed. However, the complainant may be asked to explain any delay in coming forward. And so if there has been a delay, obviously it's a good idea to think about what explanation the complainant may have for that. And of course, you know, as someone who represents survivors, I know there are many, many reasons why people don't come forward. Everything from fear of being blamed, you know, misplaced shame that they may have, you know, not being psychologically ready to come forward. There's so many reasons, and many of my clients don't come forward for even decades. Now, not every police officer is as educated on some of those reasons why there is delay in coming forward, and that's why I suggest that the complainant give some thought to how to answer that question if it's posed. So what are some of the advantages of the criminal justice system? Well, the first is that the police investigate and the Crown prosecutes all at no cost to the complainant. The complainant's role is minimal. They are a witness for the Crown. They don't have to have a lawyer, and the burden is not on them to carry the case. Obviously, if there is a conviction, although the justice system, the criminal justice system, is primarily about punishing the wrongdoer, there can be some benefits to the survivor, a feeling of vindication, that justice was done, healing, closure, feeling that they have kept others safe from assaults by the perpetrator, etc. However, there are a number of disadvantages as well. Let me say straight out, it is a biased system. It is not a level playing field between the Crown and the accused. It is biased in favor of the accused. The system is intentionally designed that way. And when I have clients who are going through a criminal proceeding, I make this very, very clear to them from the outset, because there are many occasions during a criminal prosecution where the survivor feels this isn't fair. You know, why does he get this and I don't get this? Okay, and so it's really important that they understand we designed this bias system for actually a pretty valid reason. And that is, we want to make sure that we don't put innocent people in jail. Most people are familiar with the old saying, it's better to let 10 guilty men go free than convict one innocent one. And that's sort of the underlying premise. We give the accused all sorts of advantages: a presumption of innocence, a high burden of proof on the Crown, one-way disclosure, meaning the Crown has to disclose everything about its case to the defense doesn't have to disclose anything to the Crown. So if the survivor knows going in to expect that it is not a fair or balanced playing field, that makes it somewhat more palpable. The other point, of course, is the complainant is not a party. They don't have a right to representation by legal counsel, and that can feel really disempowering. And the complainant can be somewhat outside the process, often left trying to figure out what's going on with the case, etc. Now, we do have the Victims' Bill of Rights, which was intended to redress some of these concerns, and that gives victims the right to be informed through the proceedings and sets up victim services office, etc. But again, the victim is not driving the bus in the criminal justice system. And of course, if there's no conviction, that can be extremely invalidating. Now, judges don't typically find that complainants, particularly in sexual assault cases, are lying. They'll say something like the Crown hasn't met its high burden of proof, but still it's something the survivor has to be prepared to live with as a possible outcome when going in. Okay, so how will it actually go? So first step is to make a report to the police, and the report has to be made to the police in the jurisdiction where the offenses occurred, the local division. I always suggest making a phone call first rather than just showing up and seeing who you get on the desk. Particularly if it's a sexual assault case, you want somebody from the sex crimes unit, and hopefully that can be arranged by a phone call in advance. The police will then do whatever investigation they deem appropriate. If they lay a charge, the accused person will be brought before the court. One important thing to keep in mind is that there can be numerous court dates before anything actually happens. And again, I like to explain to clients there's actually a legitimate reason for this. The law is that if the court adjourns the case with no specific set date for the accused to come back, they lose jurisdiction over the person and the offense. So they can't just say to the accused person who shows up in court the first time without a lawyer, come back when you get a lawyer. That'll be the end of the case if they do that. So what they do is they set another date, a month or 2 or 3 away, and say, okay, come back on this date. On the second date, do you have a lawyer? Well, I called 3 lawyers, but, I haven't yet retained one. Okay, come back in 3 months. Okay, yeah, I have a lawyer, but my lawyer couldn't make it today. Okay, come back in 3 months. So you can see why that happens. Now, again, if the survivor is prepared for that and understands that there's no other way to do it, they don't want to adjourn it for a year to make sure he gets a lawyer, because then you're up against this possible defense of he's been denied his right to a trial within a reasonable time, which could result in charges being dismissed. So they have to come back again and again and again at intervals to get anything done. In some criminal cases, depending on the charge that's been laid and how the accused elects to proceed judge or judge and jury, there can be a preliminary inquiry. And that's like a little mini trial where the Crown has to convince the judge that there's enough evidence to go to trial. A transcript is kept, and of course, if there's an ultimate trial, any evidence given at the prelim could be used to contradict witnesses at the trial itself. So it's as serious and as important in terms of evidence giving as the trial itself. I explained earlier that generally the complainant has no right to counsel. Generally that's true. However, if, for example, the defendant wants access to the complainant's counseling records and feels they need to have those to have a fair trial, then under the criminal code, the complainant has a right to independent counsel in those circumstances. But again, it's very limited. Usually, because they don't have the burden to prosecute the case, and they are not the one being charged, they do not have a lawyer. At trial, trials look pretty much how they do on TV in the sense that there are witnesses and exhibits and evidence marked, etc. It's a lot less dramatic in Canada than some of the antics you see on American court TV. Hopefully the Crown Attorney does a reasonably good job in terms of preparing the complainant to give evidence, but it can be very last minute. Sometimes it's helpful for the complainant to go to court and watch other trials in advance of giving evidence. So let's flip over now to civil lawsuits. The civil justice system has a very different purpose. The purpose of the civil justice system is compensation for the harm done to the plaintiff, monetary damages. The parties are individual plaintiff against individual defendant and or institution. In a domestic violence case, there's not usually an institution involved, of course, but in other kinds of cases there might be. There are three main issues in the civil case. The first is liability. That's the civil equivalent of guilty, not guilty. And the important thing to know here is it's a much lower burden of proof. It's proof on what they call a balance of probabilities. More likely yes than no. If you tip the scale 1% in your favor, you win. Now, interestingly, if there is a prior criminal conviction, that is admissible as proof of liability in the civil case, and it's irrefutable proof. If someone has been convicted of a crime, in a criminal case, they cannot deny in the civil case that they did it. Or, well, I guess they can deny it, but they're not going to succeed. If there is no criminal conviction, it is still possible to get a finding of liability, and that's what happened in the O.J. Simpson trial. He was not guilty criminally, but he was ultimately found liable civilly. But of course, if there is no conviction, then you have to prove in the civil case that the offense occurred. But again, it's that lower burden of proof. Now, in many assault cases or sexual assault cases, not assault cases, but in sexual assault cases, the defense is consent. And there are, of course, some circumstances in which a complainant cannot consent. If they're underage, if they're unconscious, if they're completely incapacitated by drugs and alcohol, etc. But most cases turn on credibility and whether or not consent was given. Now, many lay people have ideas about what they think may constitute corroborating evidence. And I just wanted to talk for a minute about a couple of those things. Firstly, prior consistent statement. Often people will say, well, I told my therapist about this and she wrote it down, or I told my friend, or I told my partner. Generally, those prior consistent statements, I said this before to somebody else, are inadmissible. There is one main exception when they could be admissible, and that is if the defendant alleges recent fabrication. You just made this up last week because you're trying to get money from me in our divorce settlement. Okay? So if the defense is you recently made this up, then a statement made previously could be admissible to refute that defense of recent fabrication. But otherwise, generally, prior consistent statements are not helpful. Confessions, admissions are helpful, and and those could be something in writing or text messages or even phone calls that are recorded, etc. It's not illegal in Canada to record a phone call if you are a party to the phone call. What is illegal is to intercept a private communication between two other people. But again, whether or not the recording is going to be admissible in court depends on a number of circumstances. But sometimes confessions or admissions can be helpful corroborative evidence. Similar fact evidence. Again, a lot of times people say to me, well, you know, he did this to my cousin as well, or, you know, he beat his first wife as well. Generally, evidence that a person did one bad thing is not admissible to prove they did another bad thing unless you meet the test of similar fact evidence. It's a very high burden, and you have to basically convince the court that the evidence is so strikingly similar that as to show a pattern of conduct to make the evidence more probative than prejudicial. You can't say, you know, because he robbed the bank, he assaulted his wife. That kind of thing is not going to be helpful at all, not admissible. There is a new tort that I wanted to bring to everyone's attention. This is a very interesting family law case. Most times, civil cases are civil lawsuits. Family law is generally dealing with matters such as divorce, division of property, custody of children, child support, spousal support, that sort of thing. But in this recent case, a court ordered significant damages, pain and suffering damages, loss of earning capacity, aggravated and punitive damages for what they called a new tort. That's a civil wrongdoing. And basically they said that this new tort exists when there is conduct that is violent or threatening, constitutes a pattern of coercive or controlling behavior, or causes the family member to feel fear for their own safety or that of another person. So this is interesting because this whole idea of family violence came to be in the Divorce Act, which again really doesn't deal with awarding money for fault in the context of support or division of property, etc. The whole idea of this family violence was put in the Divorce Act because it could be relevant to who gets possession of the home or custody of the children or things like this. But in this case, the judge actually created a new civil legal wrong. How is it different than what we had before? Well, before, the focus would always be on each separate assault. You know, you were assaulted 3 times, and what are the damages that flow from that? Or you were sexually assaulted 1 time. This new tort allows the court to look at the entire pattern of conduct, possibly even over decades, and award damages on that basis. To meet the threshold of a finding of family violence, you have to show that there was more than one incident of one of the following things: sexual, physical, or psychological abuse, forcible confinement, threats, harassment, stalking, failure to provide necessaries of life, financial abuse, or killing or harming an animal. And if you meet that threshold, then the court can look at the entire relationship and all the abusive conduct that occurred during it. So interesting. In that case, as I said at the beginning, there was $150,000 awarded. I want to go through now, if I can, some of the damages issues, because although civil cases are not usually just about money, there are all sorts of other goals. Some of them I've listed here on the slide. Really what the court has the power to award at the end of a civil case is a monetary award. And that money can be very important to an abuse survivor for needed therapy or education or all sorts of things. Generally, there are several types or heads of damage. The most common is general damages for pain and suffering. A cap was put on pain and suffering in Canada. I won't go through the history, it'll take too long, but basically it was established at $100,000 in the late 1970s. With inflation, it's up to $407,000. There have been some cases which have questioned whether the cap should apply at all in sexual assault cases, but there's been no real push to go over that cap, which currently with inflation sits at about $407,000. So what are the factors the court considers? Well, in a sexual assault case, or a physical assault case for that matter, they look at the nature of the act committed, the duration of the assault, the survivor's age and vulnerability, and the impact on the survivor's life, including education and career. And of course, the range is huge depending on all of those factors. In addition to pain and suffering, there may be available damages for past or future therapy. Past, obviously, is what's been spent. Future, you would need expert evidence from a therapist to explain what will be needed in the future. Similarly, for past and future income losses, the past may be simple to calculate if the survivors missed time from work, but future income losses, you may need a vocational expert or an economist to predict into the future what that impact on education may be. Also, another head of damages is punitive damages. In the old days, the law used to be if the perpetrator was convicted criminally, that was punishment enough. The court wouldn't award punitive damages on top to punish the offender. Now, the Victims' Bill of Rights says that a criminal conviction is only a factor to consider. Punitive damages can be awarded, notwithstanding that there's been a criminal conviction. The last type of damages available in these cases are family law claims. And these are claims for parents or children or other family members who were in a relationship at the time the assault occurred. And they are entitled to an amount to compensate for damage to the relationship called loss of care, companionship, and guidance, or any out-of-pocket expenses they have incurred, or compensation for services they've provided, or income they've lost as a result of their family member being hurt. The third issue in a civil case, so we've got liability, damages. The third issue is judgment enforcement. And unlike criminal cases where the government takes care of enforcing the sentence, in a civil case, the plaintiff, the person suing, has to enforce the judgment, meaning you can't get blood from a stone. So if the defendant doesn't have money to fund a settlement or pay a judgment, the civil action is not a good idea. Now, the bad news is if the abuse survivor or the plaintiff has no idea what the defendant's financial circumstances are, they have no right to that information unless they go through a lawsuit, get a judgment, and the defendant refuses to pay. If there's an unpaid judgment, at that point they can do an examination called the judgment debtor examination and ask all about their financial situation. Now, in some cases, if it's a domestic violence situation, the plaintiff may know all about the defendant's finances. But if they don't, the only publicly available information would be property searches. So if you have a municipal address, you can look at title to the house, you can get the MPAC value of it, and see what mortgages are on it, and therefore conclude with some accuracy what the equity in the property might be. But in terms of bank accounts or other assets, not possible to know what's there until after you have a judgment. And as I tell most abuse survivors, if there is no property, no significant equity in property, and you're looking at seizing assets like cars or boats, unless it's a yacht, the cost of going to trial and getting the judgment and seizing the asset and selling it may be prohibitive. And the cost of garnishing wages, at whatever the cap is, I think it's 20% you can garnish of somebody's wages. By the time you've gone through a civil trial, you will have incurred thousands, if not hundreds of thousands of dollars in legal fees, and garnishments are not really going to help you dig your way out. So unless you can see a lot of equity, you want to be asking these questions before you even start a civil lawsuit. Confidentiality. I talked about publication bans in criminal proceedings. In a civil lawsuit, a plaintiff can proceed by use of a pseudonym, Jane Doe, etc. You have to get permission from the court to do this, and there are a number of factors the court will look at, including whether there's been a publication ban in a criminal proceeding, whether there's media attention, whether the plaintiff's identity is a matter of public interest, like is this a famous person? Will other people be deterred, or will this plaintiff be deterred from coming forward if their name is put in the newspaper? Will the plaintiff suffer psychological harm if their true identity is publicized, etc.? My experience is courts usually favor plaintiffs, and they get these pseudonyms when they want them. Another confidentiality issue that arises is at the back end. You know, the proceeding by pseudonym, that's what you do when you start the case. But at the end of the case, when the case settles, and most cases do, frankly, end up in a settlement as opposed to a trial, at that point, the survivor may be asked to sign a gag order or confidentiality agreement. And there's been a lot of discussion and the potential harm caused by gag orders going back more than 15 years ago at the Cornwall inquiry, which made recommendations against silencing victims. More recently, Prince Edward Island has actually enacted legislation prohibiting non-disclosure agreements, NDAs, another term for gag orders, in some situations, and put severe restrictions for other situations. I think there's an argument that they may be void as against public policy, meaning if a survivor signs a gag order or agrees to a confidentiality agreement and later breaches it, it may not be enforceable. But again, as a lawyer, I would not be advising clients go ahead and breach it in the hope that a court will find that it's void as against public policy, because certainly that survivor could be sued for damages, and the outcome is far from certain. So as a result, I suggest that survivors be very, very, very careful when agreeing to any kind of confidentiality agreement or gag order. Not only thinking about how they feel today, but trying to predict well into the future how they're going to feel down the road. And there is no one size fits all, right? Like, it's very different to agree to keep the terms of settlement confidential and not tell anybody how much money you got, or even to keep the fact of settlement confidential versus not being able to talk about your abuse. Okay, those are two very, very, very different things. Agreeing to keep the amount of money confidential may have no harmful effects on the survivor, whereas a gag order preventing her from ever discussing what happened could be very, very damaging. As well, even if you do agree to keep allegations confidential, or even just the fact in terms of settlement confidential, there are some standard exceptions that almost any defendant will agree to. And so these kinds of clauses require careful thought, consideration, and often extensive negotiation. But certainly, people should not sign them without turning their mind to the longer term impacts. Time limits. So there's a general rule in Ontario that you have to sue people within 2 years. But in 2016, Bill 132 eliminated all limitation periods for any lawsuit based on sexual assault, any lawsuit based on other misconduct of a sexual nature if one of the people, if the complainant was a minor, or if there was a relationship of trust, authority, or dependence, and also no limitation period for physical assault if the plaintiff was a minor, or if there was an intimate relationship or a relationship of dependence. So what that means is basically no limitation period, no time limit for suing for sexual assault or domestic violence. And these changes are retroactive and they apply, doesn't matter when the assault occurred, whether there was any previous limitation period that expired, etc. The only time it doesn't apply is if a case has been finally determined by a court or has been settled. Important exception, the Trustee Act, which puts a limit on suing dead people, a time limit of 2 years to sue the estate, that may or may not apply in a case of a physical assault or sexual assault. The law is still in flux on that issue. So if the perpetrator has died, to be safe, you need to sue the estate within 2 years. Advantages of the civil justice system. The plaintiff has a great degree of control over the process. It can be very empowering instructing the lawyer when and how things are going to be done. It's a lower burden of proof. You can get financial compensation that's not available in the criminal justice system. And of course, most cases settle short of a trial. A lot of criminal cases settle with a plea bargain too as well. I didn't mention that, but not all criminal cases go to trial. Often a deal is made with the Crown. You know, you plead guilty and we'll recommend a lighter sentence. Some of the disadvantages, though, of the of the civil justice system, the complainant has no right to privacy. When you go to court and you ask for money, you open up the books on your life, your therapy records, your financial records. You know, if you're making a claim that you have suffered psychologically, you know, you have to submit to an examination for discovery and talk about every other traumatic experience that's happened in your life. So that's an important thing that survivors know going in. Also, they can take forever and cost a fortune if the defendant fights it all the way. I'm talking 3 to 5 years to get to trial, and not just tens of thousands, but potentially legal costs in the six-figure range. There is a risk of a counterclaim or a finding of a cost. If you're unsuccessful, you may be required to pay a portion of the defendant's legal fees. For a while, it was a bit of a fashion for defendants who were sued to counterclaim for malicious prosecution or defamation. I've probably seen about a half a dozen of those kinds of cases, as opposed to literally thousands of cases going the other way. In terms of the ones I know about, other lawyers and reported decisions, et cetera. It's a relatively rare event, but again, the survivor should be informed that it's a possibility. I've never seen one go very far, personally, where I've represented the survivor. There have been one or two that have gone to trial and gotten a lot of press, but it's a relatively rare occurrence. So how does it go? Well, the plaintiff, unlike in a criminal case, they don't get assigned a lawyer. They have to choose a lawyer. So, you know, things to think about are, what is the experience of the lawyer? Does the lawyer have a track record for going to trial? Is the lawyer willing to take a case to trial? What are the financial arrangements? Most lawyers who do this work will work on a contingency fee basis, meaning they charge a percentage of the outcome. I would be very skeptical of any lawyer who wants to proceed on a retainer and pay-as-you-go basis. My feeling is if it's not a good investment for the lawyer, it's probably not a good investment for the client. It starts with an exchange of paperwork. The plaintiff sets out in writing what their claim is, and the defendant files a defense. Then you go through a disclosure process, which involves both records that are relevant, as I mentioned before, no right to privacy. Depending on the nature and extent of the claim made, you may have to produce therapy records, employment records, all sorts of things, as well as submit to an oral examination for discovery, where each party gets to question the other about the facts and information they have that's relevant to the case. There can be procedural motions along the way where parties fight about things like whether or not proper documents have been produced, etc. But ultimately you end up at a pretrial conference, which is a settlement meeting with a judge, and also a trial management meeting. So if the case can't be settled, the judge will help you sort out issues you need, and ultimately a trial, which again looks like what you see on TV, but a lot more civilized here than it is in American TV. So some practical information in addition to what I've already given you. In a civil case, the plaintiff's lawyer is subject to solicitor-client privilege. And that means that everything that the client tells the lawyer is held in the strictest of confidence, and the lawyer can never be required to disclose what the client has told them unless the client has waived the privilege. It's sacrosanct. Not even a priest has this kind of a privilege with a parishioner. On the other hand, with a Crown attorney in a criminal case, not only is there no solicitor-client privilege, in fact, the Crown Attorney has a positive obligation to disclose to the defendant anything that's relevant to the defense. So whatever the complainant tells the Crown has to be told to the defendant. Whereas in the civil case, nothing can be told to the defendant. So it's the opposite. In either scenario, so in other words, you got to be careful what you say to a Crown Attorney. You don't have to be careful what you say to your own lawyer. That's the bottom line. Full disclosure is important in either case, including what the survivor views as bad facts. You know, we all watched the Ghomeshi trial go south primarily because there was a bunch of factual information that never came out during the trial until cross-examination. Stuff like the complainant stayed in touch with Ghomeshi after the fact because they were trying to normalize the situation, trying to mitigate any damage on their careers, etc. Had they told the police, had the police asked them, had they told the police, had this come out in chief in direct evidence by the Crown, it would have been less of an aha moment as it was in cross, and perhaps not hurt their credibility at all, and the outcome may well have been different. I wasn't involved in that case, I'm just speculating, but I'm saying you don't want to hide bad facts because when they pop up for the first time in cross-examination, it undermines credibility. Preparation is everything. Now, in a criminal case, the complainant doesn't have a lot of control except reading over what documents she's been given, if there was a prelim, reading over the transcripts of the evidence she gave, etc. If she gave a police statement, reading over the police statement, etc. You'll notice I default to she and he, she for victims and he for perpetrators, just because statistically that's the way it usually happens. I am in no way suggesting that victims can't be men and perpetrators can't be women. It's just a habit. But in the civil case, there's much more opportunity to prepare extensively with counsel. Every question that's going to be asked, every answer that's going to be given, reviewing every document, every record, and having deep and lengthy discussions about strategy and you know, demeanor and all sorts of things. Communicating with lawyers, this is just a little bit of a practical tip. It's always a good idea to put things in writing, not because you're going to have to prove it later or put it in an affidavit, but it's just clearer and more specific. And oftentimes I have clients calling me saying, my lawyer won't answer me, can you help me, etc. And my advice always is, put it in an email. People respond to things in writing. Now, you won't have the email of the Crown Attorney, but you may have the email of the victim services person or the police officer who will be your primary modes of communication during a criminal case. Managing expectations is key, particularly in criminal cases. People need to know that conviction rates are low and work out a way to be okay with an unfavorable result. Hopefully in the civil case, you mitigate against that because you are constantly assessing as you go along and making decisions about settlement based on your assessment of outcomes. You have much more control over the outcome in the civil case. Concurrent civil and criminal are not recommended. Better to have the criminal conviction going into the civil action. It refutes any I didn't do it defense, but also you don't want any cross-examination by the defense lawyer in the criminal case along the lines of financial motivation. You're just doing this for money. So better not leave the civil case, particularly because there are no time limits in suing, and deal with that after. Also, having two or three proceedings on the go at the same time is emotionally draining and difficult. Even one is hard enough. There are a couple of other avenues, typically not in the domestic violence case, but in an employment context. There may be other administrative boards or tribunals. I've listed a few of them here. I'll make the presentation available after the fact. I think I'm 1 minute away from being done, which if there are no questions is perfect timing. And if there are questions, I'm happy to take a minute and answer anything. I haven't seen anything come up in the chat as yet. But as well, do I think restorative justice measures can be more beneficial than traditional justice? Even though it does not guarantee money compensation, it does provide closure and an active role for the victim in the process. Yes, I agree. I don't have a lot of experience with traditional or typical restorative justice processes, but I have been involved in a lot of mediations as part of a civil process where apologies are given, and those sorts of things can be very healing. As I mentioned, civil cases are not usually just about the money. So yes, I agree that restorative justice is something that ought to be considered, but you have to have a willing participant defend it. You can't hold a gun to somebody's head to get them to participate in restorative justice in a meaningful way. Okay, I don't see another question, and we are at 11:45. So thank you, everyone, for listening. And again, my email and phone number are up there on the screen. So if you have a question that you didn't feel comfortable posing in this forum, please feel free to send me an email. That's the easiest way to get in touch with me. And thanks for listening.
Thanks so much, Loretta. We'll now be breaking for lunch until the conference resumes at 1 p.m. I invite you to return to the lobby for up-to-date communications. And I also encourage you to visit the trade show or exhibit hall to gather some great resources. Then I hope you join us at the main stage at 1 p.m. for our next keynote speaker. Thanks again.